I know Brittany usually does our weekly workshops, and she is actually still on vacation. She's taking a vacation day. I wanted to chime in though, and I have invited Kate, who's graciously agreed to help, even though she's not feeling well, to talk about some of our new forms. I don't know if all of you are aware, but almost every year, CAR either revises, takes away, or gives us new forms. And this year is no different. I was able to go to the legal update with Gov Hutchinson, who is our CAR head legal attorney, and he's always interesting to listen to. So most of the revisions and changes that we have, thank you, Ross, are not too significant. They're not major, and yet we need to be aware of them. Okay, so I'm gonna go ahead and put the link in again because we've had a couple other people join us. This is where you can find the summary of the forms that have been changed, and I have them saved here. So I'm going to be sharing my screen and pulling them up, and we're going to go over some of the new things and changes and revisions. A lot of them don't affect us as realtors. A lot of them affect the rental world for this year. So our update was only like an hour and a half, which was pretty fast. Wouldn't you say, Kate? They're usually 2 or 3 hours.
Yes, yes.
And this one was pretty fast. So Kate, at any time, feel free to chime in, okay?
Thank you so much.
All right. And so for those of you that don't know who Kate is, and those of you that just came on, if you could turn cameras on, we would appreciate that. And Kate is joining us today. She is the broker manager in the Paso Robles office. And so she's here to help us out as well. Okay, I'm going to share my screen. Hi, Valerie. And we're going to just go through the summary. And then there's about 4 of them that I've chosen to actually talk about. Now, we'll talk about as much as we can in this hour. Please note, tomorrow there is no contracts class with Troy or CB. The contracts Kung Fu is not happening tomorrow. However, next Thursday, it gets back on track. It will be happening every Thursday at 1. And CB today, in one of the meetings I was in with him, said, please come. They will be talking about these new forms and things, and please come with your questions. It doesn't have to just be what they're presenting. They want you to bring your questions, okay? So first of all, the RPA, and this is one we're going to go through after we do the summary, the RPA does have some revisions, but you'll notice that on the far right of this grid, it says that it's okay to use the prior version. So basically, the revisions on the RPA, there's nothing super significant. It's mainly clarifying some things. And you'll notice when we get to a couple of the things they're clarifying, every time they do it, it's because there were issues with the wording and with problems throughout the year. And so they have taken care of that. So we'll go through them. I have a sample of the new document, and they've put in red all the changes. So we'll be going through that shortly. Okay. This one is really cool. I don't know if everybody is aware, but there were 3 buyer representation agreements, and we would often get asked which one do we use. So we used to have the exclusive, the non-exclusive, and then the non-exclusive not for compensation. And that could get confusing. Well, they have done away with all 3 of those, and we now have 1 buyer representation and broker compensation agreement. We are going to go through this one as well. Super easy to use, and I think you guys are really going to like this. There's a few things, because they're not normal, we don't really talk about them. I'm going to just kind of skip over for now, but if you have any questions about them later, if there's time, you can ask, or make sure you ask our brokers. Okay. Brand new one is an anticipated broker compensation disclosure. This is brand new, so we've not had it before. It advises the buyer that seller's payment of compensation direct to a buyer's broker or indirectly through the seller's broker may impact the price the seller will accept, and that the buyer's broker will disclose on a property by property basis the compensation promised broker through the MLS or elsewhere. Part 3 is where the buyer broker discloses the final compensation received. I do not know if this is going to impact us or be a required form. Kate, are you familiar with this one yet? And before you answer that, let me set the stage here to everybody that's here. These are all brand new, and we are all, including your brokers, just learning them and figuring them out. So bear with us on this, okay?
A great disclaimer, yes. Okay, I have read through it. I have not inculcated it into my my transaction wisdom yet.
Okay, fair enough. And it sounds like, because I know there's been talk, and Kate, correct me if I'm wrong, or if you know any more information about this, but there has been talk about NAR wanting to require the, not only do we have to put the buyer compensation in the MLS, which is common and everyone does that now, but they're soon going to be requiring the entire amount to be put in there, as well as what's being offered to the buyer side. Isn't that in discussions, Kate?
It is in discussions, yes.
So my guess is that this has something to do with that.
Mm-hmm.
Okay, buyer transactional advisory. This is going to be bundled with the BRBC, which is what we just talked about, the buyer representation broker compensation agreement. So we have new acronyms to get used to, or new letters to get used to. And giving more information about the agent's responsibility and the things that the buyers need to take care of. Cancellation of buyer representation. This is also brand new. So it's a 2-part form. Part 1 is where the buyer gives notice of cancellation to the, or buyer or broker gives notice of cancellation to the other. A signature is required in part 1 below paragraph 2. Paragraph 3 of the form identifies the compensation that would be due the buyer's broker. So it reverts back to the BRBC, or the buyer representation agreement form, and applies to any applicable property purchased or only those for which there was a broker involvement. So basically, if you have a signed buyer representation agreement and somebody's wanting to cancel that, either side, this is the form you would use in layman's terms. That's takes that paragraph and simplifies it, I think. Brand new form, notice of broker involved properties. This would be used at the termination of buyer representation if a protection period was provided. This is not something we've used before, and I'm sure we will get additional information. What I can tell you is on all of these forms, when I listened to Gov Hutchinson speak, he didn't give us a lot of detail on anything, which means a lot of these things are things we may not even really be using on a regular basis, but we do need to be aware that they're there, because there could be that one situation that comes up 5 years from now. This is a new one that you will have to be aware of because of the new buyer representation agreement, which we'll discuss in a few. And this is the other one we'll discuss: seller payment for buyer's broker. There is a new addition on the RPA talking about this. So I won't go into it right now. We'll talk about it all together. Okay. Lease listing agreement. Most of us are not working with that. We're going to skip over that for now. Property management agreement. Anyone under our brokerages is not allowed to do property management under our brokerages. So that is a non-issue currently. Rental property disclosure, residential lease, or month-to-month rental agreement. As I mentioned on the outset, a lot of these have to do with rental and property management type things. Okay. This is new. The DEDA, Designated Electronic Delivery Address Amendment. This form would be used as to provide a designated electronic address or an email for delivery of documents in case the fields were left blank on the RPA. So it is important, guys, that you fill in email addresses on the RPA, because that is typically how we deliver documents now. So please make sure that you're not leaving that information off. And if for some reason it was left off or was unknown at the time, this would be the new addendum or amendment form that you would use to provide that information. Okay, move in, move out inspection. That's related to rentals. pre-move out inspection, notice of right to inspection prior of termination of tenancy, lease, rent. So we're going to skip over those. Non-contingent offer advisory. This is like the existing market conditions advisory. Some of the market centers use that, some don't. This new form notifies a buyer of the risks associated with making an offer without any contingencies, and specifically describes the contractual value of a loan contingency, an appraisal contingency, and an investigation contingency. So this is one, whether you use it or not, whether it becomes required or not, because we don't know which ones of these will be just yet. You should know what this one says. It's always best to err on the side of safety with the buyers, and never be the one to recommend that the contingency should be removed. That would only be done if the buyer is asking for them to be, and you would still want to give them all the possibilities that may or may not happen if those contingencies are removed. Okay, this is a new one. This one I think I'm happy about. Because solar is a problem. Yes, it is a common concern, Michelle. So this one is a brand new form. It's in two parts, and this is one that I pulled up that we are going to look at. So I'm not going to go over too much of it, but the gist is in the notes here that paragraphs 1 through 5 are an advisory and describe the most common types of solar systems, ownerships, leases, those types of things, how payments work, what gets transferred with the sale of real estate, and the importance of reviewing all the documents. And then there is a second part that's 20 questions that a seller should answer to the best of their ability, that they are aware of. So in other words, it's kind of a TDS for solar. And if you have a property with solar, my guess is this is going to become a required document. I don't have confirmation of that. Whether it is or isn't, I would highly recommend using this if there is solar in your transaction. Would you agree, Kate?
I absolutely would. This little document feels to me like it's going to solve a lot of problems and save us a lot of research and headaches.
Yes, because solar is one of the biggest pains in the tuchuses of a real estate transaction.
For many reasons, yes.
Yes, so I love this one. Okay, buyer counter offer. And notice off to the side here, the far right column, that is stating whether or not it's okay to use the prior one or not. Okay, and so this one is saying no. Okay, so this is not new, but there is some language that was added to 1B, that the seller credits in the offer remain unchanged even if purchase price changes. There's also new paragraph 1C that clarifies the difference between the offered price and the appraisal contingency amount will remain the same even if the purchase price changes. So when you're doing counteroffers, make sure you're reading them thoroughly and explaining to your buyer and your sellers what the language means. Okay, and if we have time, we can look over that one. Cancellation of contract and disposition of deposit and cancellation of escrow. So we can no longer use the old one. There was some language that was added to this one that's proposed mutual cancellation, setting a time for the recipient party to respond. And if there's no timely response, the proposal expires. So in other words, they can't just say, okay, if you don't answer in 10 days, we're canceling. They can't arbitrarily do that, is how I understand that. California Consumer Privacy Act, advisory, disclosure, and notice. The language of the existing one was shortened and revised. Wow, something was actually shortened. Go figure that one out. And it's because they added a URL where you can get more information. Okay. Extension of time amendment. This has been changed. The form was changed from an addendum to an amendment by adding paragraph 5, which establishes a time for the recipient party to respond If there is no timely response, the proposal to extend time expires. So that's one thing that I remember Gov talking about when we met with him, was a lot of these things are being changed from addendums to amendments because we are actually amending the contract. Okay, manufactured home and home purchase addendum. Language was added incorporating the terms of the existing manufactured home advisory, addendum, and release, which was the MHA form informing the parties and making contractual requirements for the condition of the mobile manufactured home if it's to be occupied. Okay, the existing form was reformatted as far as the TDS for manufactured homes. And residential lease after sale, we don't use this one very often, but please note that there are some changes to that one.
Could I jump in, Jodi?
Please.
We do use this if the seller holdover period is going to be 30 days or longer. And there has always been a lot of confusion about the security deposit. And they've added language that just makes it crystal clear. This is a very good improvement. It is. Awesome.
Thank you for that. And also on that note, just as a side point, if you do have a buyer who is allowing a seller to stay in a home for more than 29 days, so if it goes to 30 days or more, that's when this form is required, correct, Kate?
Correct.
29 days or less, you don't have to have an actual rental agreement. But if it's 30 days or more, you do.
And if it's 29 or less, we use a form called the SIP, seller in possession. And
yes.
The difference is the SIP is a license to stay. But it is not a lease. The RLAS is an actual lease.
Okay, thank you.
That probably wasn't clarifying, but both forms should be in place depending on the agreement.
Yes, absolutely. Never ever let a seller stay in possession without the proper form in place. Yep. That's just asking for trouble.
Yep.
Okay, seller counter offer. Language was added to 1B that seller credits in the offer remain unchanged even if purchase price changes. New paragraph 1C clarifies that the difference between the offered price and the appraisal contingency amount will remain the same even if the purchase price changes. And I can see why they make these clarifications, because sometimes people assume if I'm taking 5,000 less, if I agree to 5,000 less, then I'm going to give you 5,000 less in credits. So it's good that they're clarifying a lot of these things. And the seller multiple counter offer, the same clarifications. Okay, so we should not be using the old versions of any of those forms. Okay, so that is the synopsis of the changes. So what we're going to look at first, the most important one, is going to be the RPA. To be clear, we're not going to go over the entire purchase agreement. We're going to skip through to the parts in red that we need to draw your attention to, okay? So our first clarification is buyer to pay up to X points to obtain the rate above. I actually meant to pull up the old one because I can't show two windows at the same time. But I want you to be able to see the difference. And you'll notice that essentially these sentences say the same thing. They're just a little bit clearer. Okay, this is the part that I was talking about where they completely added. We now have a G3. And this is the seller agrees to pay the obligation of buyer to compensate buyer's broker under a separate agreement. That's the SPBB that we'll talk about after this, okay? So seller's broker's offer, if any, to compensate buyer's broker is unaffected unless otherwise agreed. So to put this in layman's terms, we now are going to have the buyer representation agreement. Well, you know what? Let's do this. Let's go ahead and pull it up so we can have the conversation and have it make sense. This is the one that replaces the 3 other ones that we had. So what you need to know is that right here in the very first sentence, it's the first 3 lines essentially are the same. However, notice where it starts with the little double I's here. Upon completion of resulting transaction, whichever occurs first, the non-exclusive right to represent buyer in acquiring real property or a manufactured home. So the way this agreement is written, it's written as a non-exclusive. So in order to make it an exclusive representation, you would need to check the box down here on number 2, on B2. And now this agreement shall be exclusive and irrevocable. Broker will devote time and resources to assist buyer in finding and acquiring property. So basically what you guys are already used to using, okay? The rest of this is the same, putting in the location. They have cities, counties, price range, other. Remember, I always like you guys to not get too specific there because you don't want to box yourself in and give the buyer a reason to get out, but definitely have California or something like that in there. Everything else is pretty much the same, okay, as far as I can tell. Kate, did you notice any other big differences?
You know, that whole first page, I thought bore drilling down on. 4D caught my eye.
Okay. Accounting for payments to brokers by others.
Yeah.
If anyone other than buyer compensates broker for services covered by this agreement, that amount shall be credited toward buyer's obligation to pay compensation. Well, thank you for bringing that out because I missed that. That goes along with what we were learning today at the Central Coast meeting with the SPBB. I'm learning the new ones, right? Because on here, what you're able to do is you can have a buyer agree to pay your commission. Let's just use 3% as an example, okay? So if your buyer is going to agree to pay you 3% for representing them, meaning whatever you find them to purchase, whether it be in the MLS or it be new construction or a FSBO, whatever compensation they offer, if it doesn't add up to 3%, the buyer's guaranteeing you're going to get 3%. If I understand Kate correctly, this D1 would go along with the SPBB, which we'll look at. That the box that we just saw in G3 on the new RPA, if that box is checked, and let's just say that the compensation in the MLS is 2.5%, but that box is checked, now the seller is agreeing to pay the full 3%, meaning the additional 0.5% that the buyer promised to the agent. Are you following me?
I don't know that I am, and I don't know about anybody else. I would love to get Gov's take on that, how a buyer's agent could commit a seller to pay for anything outside of their contractual agreement on their listing agreement.
No, okay, hang on, let me stop the share. Okay. That's why all of these forms work together, because remember, I just showed you on the RPA. Let's pull that back up again. And they're not, to be clear, Kate, they're not going to pay them any more than what the buyer representation agreement says. So look at G3. Seller agrees to pay the obligation of buyer to compensate buyer brokers under a separate agreement. So the way I understood it is seller says they're going to do, they've done 2.5% to pay the buyer, but buyer agreed to pay agent 3% or broker 3%.
Mhm.
If this box is checked and seller accepts it, now seller pays the additional 0.5% to total the 3% on the buyer agreement.
Okay. Okay. Good job explaining that.
Is that better this time?
Yeah.
Okay. So yeah, they're not paying more than anybody agrees unless this is checked and seller accepts that check.
Okay.
Because if the listing agreement says 2.5, but new buyer's agreement says 3, buyer has this box checked. Now seller's agreeing to pay everything the buyer agreed. So the part that you pointed out, Kate, means that now the buyer doesn't owe the broker anything else because seller's paying the full amount of that buyer rep agreement.
Got it.
Jody, can I ask a
So
question?
would that change the finance terms on an RLA?
Hold on a second. Ross, you had a question?
Yeah, I just wanted to ask, so if it's not checked on the RPA, then the buyer pays the difference.
Correct. If there was that amount on the new buyer rep agreement.
Okay, so if that agreement said 3%, the property, it's 2.5, and the seller doesn't agree, so it's not checked on the RPA, then the buyer pays that extra half.
Correct.
Okay,
But they would not pay the full 3% because the seller already paid 2.5. So that goes back to that D, was it D that Kate pointed out earlier? Now remember, as I mentioned, we're all learning these are new things. Please, please, please go to Troy and CB's class next Thursday and bring these questions. And what's great about this right now is if this creates even more questions for any of us, we'll be at the ready. So we know what they're going to be talking about next week, right? Okay. Back to the RPA. You'll notice the things in red here, delivery. So I believe it used to say upon acceptance, if I remember correctly, and now it says after delivery. Okay, so really they're just tightening some things up. M3, occupied units, they've added by tenants or anyone other than the seller. You would attach the tenant occupied property addendum, and then seller shall disclose to buyer if occupied by tenants or persons other than the seller, and attach the TOPA in a counter offer if it's not part of the buyer's offer. Okay, just some more clarified language there. Let's see. Again, Q18, we have some clarified language. A lot of people were writing this in anyway, so now they've put it in for us. Home warranty plan chosen by buyer. Coverage includes but is not limited to. And then you would be writing in what they're choosing. They have added, if seller or both is checked, seller's cost not to exceed. So they've just clarified that a little bit. Instead of saying cost not to exceed $500 and both are buyer and seller, we would assume it's $250, but now they're buttoning that up and they're making sure it's what it is. Okay, and this is also something, maybe it's seller pays 400, buyer pays 100, right? So by checking buyer and seller, and by checking both, if it's not clarified, escrow could assume it's half each. There is a new addendum, mixed use purchase addendum, that is added to the list of things that we can add to the purchase agreement. In additional terms affecting the purchase price, retention of deposit, they have added this little clause here. Before adding any other clause specifying a remedy, such as release or forfeiture of deposit, or making a deposit non-refundable for failure of buyer to complete the purchase, any such clause shall be deemed invalid unless the clause independently satisfies the statutory liquidated damages requirements set forth in the Civil Code and regarding possible liability and remedies if buyer fails to deliver the deposit. So in other words, don't mess with the purchase agreement. They have attorneys go through these with a fine-tooth comb, and so we should not be going outside of that and trying to write in our own things. If there isn't a box to check or a line to write something on, we should not be adding or taking away anything from this agreement. Okay. We have an addition here for occupancy. If buyer intends to occupy as a primary or secondary residence, and unless otherwise agreed, such as in car form, the topo form, the unit buyer intends to occupy shall be vacant at the time of possession is delivered to the buyer. And the property, if the property contains more than one unit, within 3 days after acceptance, buyer shall give seller written notice of which unit buyer intends to occupy. Occupancy may impact available financing. Seller shall disclose to buyer if occupied by tenants or persons other than the seller. Attach the TOPA form in a counter offer if not part of the buyer's offer. So again, some clarification on this. All right. Just a few extra words in here. Notice for condominium, the planned unit developments, it's contingent upon buyer's review and approval. So we're going to have signature of approval on those documents. Removal of contingency or cancellation. So they not only are clarifying the 2 places on the RPA, but or elsewhere. So that could be something somebody wrote in somewhere. Again, after delivery, I'm noticing when it used to say upon acceptance, it says delivery everywhere now. Okay, this one I think is kind of funny. We had fun with this when they changed this. So as far as items included in the sale, they actually had to add any associated hardware and rods. So we kind of had fun with this when they added this verbiage, which was good because this was something that to many wasn't clear on the prior RPA. So basically window coverings, which includes blinds, curtains, drapery, shutters, or any other material that cover any portion of the window. So, you know, that sheet they just stuck up there, I guess that stays too. And any associated hardware or rods. So I guess the tacks or duct tape too. But it's just clarifying. So obviously there's been a few issues still going on this past year that they've clarified. They have added when it comes to non-dedicated devices, seller shall delist any devices from any personal accounts and shall cooperate with any transfer of service to the buyer. That makes sense, but they did need to add that in. Mm-hmm. Okay. Although still, even though they didn't change this, I want to point this out. Buyer is advised to change all passwords and ensure the security of any smart home features. It doesn't matter whether a seller delists or does anything. That it's just prudent that a buyer should change all passwords and everything. So that's just safety. Make sure your buyers understand that. Okay, so they've added tests included in inspections, reports, and certificates as far as allocating cost and who's paying for them. So they've added just a few words in here to clarify inspection, report, test, certificate, or any such document, okay? Any reports in these paragraphs shall be delivered in the time specified above, okay? Home warranty. They have just clarified what they already put in the grid. Buyer shall choose the home warranty plan and any optional coverages. And then buyer is advised to investigate these coverages to determine those that may be suitable for buyer and their cost. Okay. And they've added number 4 for a paragraph above here because of additions that they've made. It appears, I didn't catch this earlier. It appears K and L are new. So natural and environmental hazards, seller shall within the time specified above, if required by law, deliver to buyer the earthquake guide and environmental hazards booklet. And for all residential property with 1 to 4 units in any manufactured or mobile home built before January 1st, 1960, fully complete and deliver the residential risk disclosure statement. And even if exempt from the obligation to provide an NHD, disclose if the property is located in a special flood hazard area, potential flooding, very high fire zone, state fire responsibility area, earthquake fault zone, seismic hazard zone, and disclose any other zone as required by law and provide any other information required for these zones. So in other words, NHDs are required. Condominiums and planned unit developments. There's some additional additions here. Seller shall, within the time specified in above, disclose to buyer whether the property is a condominium or a planned unit development, other common interest development, or otherwise subject to covenants, conditions, and restrictions. If the property is a condominium or is located in a planned unit development or other common interest development with HOA, seller shall, within the time specified in above, order from and pay any required fee as specified above for the following items to the HOA. And then it lists the items that they will need to be paying for. Okay. Solar, this is brand new. Solar systems, this goes along with the solar document that we now have that we'll look at here in a moment. For properties with any solar panels or solar power system, seller shall, within the time specified above, deliver to buyer all known information about the solar panels or solar system. Seller may use the solar advisory and questionnaire. So this goes back to earlier, we said we didn't know if this form was going to be required. This says you may use it. My advice is to use it because it is going to be the best way for seller to disclose everything they know and maybe things they didn't think to disclose, but they'll look through the checklist and remember to disclose it. Would you agree with that, Kate?
Yes, I would. It really ties up a lot of loose ends.
Absolutely. Okay. There's an added word, contacting the insurer in the known material facts. In buyer's investigation of property, B2, investigation of any other matter affecting the property other than those that are specified as separate contingencies. Buyer's investigations include, but are not limited to, an investigation of the availability and cost of general homeowners insurance, flood insurance, and fire insurance. So that's in addition, that was not there before. And they've had to add some things because they've added things in here. And I thought there was, yeah, here we go. This goes back to what we were talking about earlier under compensation. If seller agrees to pay buyer's broker, which we talked about earlier, seller shall be entitled to a copy of the written portion of the compensation agreement between buyer and buyer's broker, identifying the compensation to be paid. And then we'll look at this SPBB in a minute, but also that would be found on the buyer representation agreement if that was signed. Okay. Nomination was added to assignment. And then down here, parties shall provide any assignment agreement to escrow within 1 day after the assignment. Any nomination by buyer shall be subject to the same procedures, requirements, and terms as an assignment as specified in this paragraph. And counting days, they have added in here, legal holiday shall mean any holiday or optional bank holiday under Civil Code something 7.1, any holiday under government code. So this is basically clarifying if it's considered a legal holiday for the purpose of counting your days. For the purpose of close of escrow, any day the recorder's office in the county where the property is located is closed, or any day that the lender or escrow holder under this agreement is closed. Okay, the close of escrow shall occur on the next day the recorder's office in that county, the lender, and the escrow holder is open. And they did put in here that unless otherwise agreed, buyer and seller agree to use electronic signatures. So that's actually in writing now. They have added in the arbitration of disputes under preservation of actions. The following shall not constitute a waiver nor violation of the mediation and arbitration provisions. The filing of a court action to preserve a statute of limitations, the filing of a court action to enable the recording of a notice of pending action for order of attachment, receivership, injunction, or other provisional remedies, provided the filing party concurrent with or immediately after such filing makes a request to the court for a stay of litigation pending any applicable mediation or arbitration proceeding. So basically, the filing is okay if it's to put it on record and needs to be clear that it is not for the purpose of litigating. And if the entity is a trust or under probate, the following is the full name of the trust or probate case, including case number. So that is going to be important to put on there. And I know we get a lot of questions on that. Again, it's down here as well. And why are these in red? Weren't those there before?
I think they were.
Okay. Well, this is new. Excuse me. Designated electronic delivery addresses, check all that apply. So this is interesting because email, it could be to a text or to a different alternate email or other such way. So we are to check how we're to deliver it to the client. And as I mentioned earlier, please make sure you put the emails on your documents because they have now created that amendment or was it an amendment or an addendum to add the email as part of this agreement if it's not on here. Okay. So it was a lot of reading, quite a few things that are on here, but yet, as you can see, except for a few key things that are kind of one-off type situations or that maybe don't happen very often, there's nothing, super scary or substantial or is going to change our lives and how we do things. Really, a lot of this is just to clarify and button things up, which is always a good thing. Okay. I do want to take a moment and let's look at the SPBB. That's a tongue twister. So the following terms and conditions are hereby incorporated and made a part of the purchase agreement dated on property known as with buyer and seller. Standard with anything we add, right? Okay, so the amount or rate of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiable between seller and broker. Real estate commissions include all compensation and fees to the broker. So then we have some choices here. One, buyer has entered into a written agreement to compensate buyer's broker. And then you would put the amount. Two, as of the date of this seller payment for buyer's broker document is signed by buyer and pursuant to MLS, so whatever the MLS says, seller's broker has agreed to pay buyer's broker X% of the purchase price, or if checked, the flat amount upon completion of transaction. So seller agrees to pay buyer's broker X% of the purchase price, or if checked, X dollar. This is where it goes back to all of these forms have to be used together, where we had that scenario earlier that we were talking about if there was a difference in the commission that the buyer had agreed to pay the broker versus what the seller was offering. Okay. And I'm sure that we're going to get even more clarification on this as time goes by. This is one that even I want to be on the next contracts class to make sure we understand this correctly. But based on what one of our brokers said earlier and things that we've been talking about, that's how we understand this to be used. Okay. So they would all have to be used together. So if you check the box that we looked at and that new line that they added was at G3, this would have to also be attached. And then the buyer side would have to show proof of the amount that they're asking by showing their broker compensation agreement. Is that, do you believe that to be correct as far as we know at this moment, Kate?
Yes.
Okay. just wanted to be sure I'm not misspeaking there.
No, I think you're really doing a good job of a pretty complicated set of docs here. You are.
They are a little, that one's a little bit different. I had to read that a handful of times before. Okay, the last thing that I want to show you guys is, now let's get back to you so I can share my screen. Here we go. The solar document. We're not going to read this whole thing. You guys can read that on your own time. It's got a little bit of verbiage here. But in the beginning, we showed you how the first 5 paragraphs are basically defining ownership, the different types of liens and purchases, and how the transfers happen based on, if it's a lease, if it's a purchase, all those types of things. Okay. However, this is the part that is going to be really, really key if you have solar in a transaction. It's in your best interest, I believe, and Kate has agreed earlier, that this document be used if you have a seller with solar. This way they can't forget to include anything important. So essentially, this is a TDS for solar. And basically the seller is just marking yes or no if they are aware of it. Like the TDS, if they don't know, they don't know. So if they don't know, they mark no. If they are aware of it, they mark yes. And anything that they need to explain would be on the lines below. So I love this form. I think this is going to be huge because it's giving a lot of information that are common questions that we don't always have easy access to.
And that we've had to do a lot of digging for, yes. Now, just so you're aware, as of a couple of hours ago, we just checked to see if we could send this form through Glide along with the TDS and the SPQ, and we are not able to do it yet, but we'll keep monitoring that.
Okay. Well, this is brand new, so we're all just getting used to these. So I'm sure that will happen soon enough. And it's not that difficult if we have to send that by separate email. I think that's going to be a very important form.
Agreed.
So we got through most of it in the hour. Any questions? I know this isn't always the fun rah-rah type class, but it's definitely the important we have to know kind of thing, right?
Oh my, yes. The essence of what we do. This is what we get paid for.
Yeah. So for those of you in the PC program, we will be this month updating the documents. Bear with us. It's going to take us a little bit of time to get that done with everything going on, so that you'll have those as samples to look at. But everything that's currently in there, it's fine to look at because, like I said, most of the things on the RPA, it's really just a matter of a couple clarifying words. So any questions, to come to Ask a Coach, email us at PC Ask a Coach, and we'll definitely help you out. Any last questions from anyone before we head out?
I'm still trying to piece my head around the buyer's compensation. So how would it be put into the RLA when you're doing the listing finance terms? You know how you do like 5% and then you break it down to 2.5, 2.5, and then you're also putting the new listing in. How will that be brought up?
So I don't think anything will change in how we do a normal listing agreement at this point. The only time that's going to come into play is if somebody has an agreement that a buyer has agreed to pay them more. And then that's when it would come into play. So as far as a regular listing agreement and seller relationship, nothing will change there, to my knowledge. And honestly, most people don't have buyers agree to pay them a compensation because sellers usually do that. Now, I don't know, I'm totally guessing at this, but we're all aware of the lawsuit that's going on with all that. And so I'm guessing this might be something to get ahead of that, to maybe some people might want to start having buyers pay compensations. I have no idea. Kate, do you know anything more about what's going on with that?
Well, that really is what the lawsuit is all about, that there is a conglomerate out there that believes that buyers should be paying their own commission. So that is the essence of it. And I think you're right. I think that they're trying to front load to anticipate however that plays out.
Yeah, I don't think it's going to really change how we do business right now. I think we're still going to be doing the same things, not asking for money from buyers or anything like that. But depending on what happens with that lawsuit or different things, if things change how we do business in the future, we're prepared.
Thank you.
You're welcome.
Hey, it's so good to see all of you conscientious people on this training session. It makes me feel very proud and hopeful for the future of our industry. And keep showing it's a good thing.
Absolutely. And let me just end with, if you guys have not fully read the documents that you use, the purchase agreement, the listing agreement, the addendums attached to them, the disclosures, please read them. Yes, they can be boring. I understand this. There are agents in this industry that have been in this industry for 20 years and have never fully read a purchase agreement, and they're signing their name to a legal document. Please don't be one of those agents.
The acronym that we scream at people is RTFD. Read the effing document. I can tell Shannon's heard that out of my mouth more than once.
Well, thank you for keeping it clean. This is recorded. Thank you so much for your input and help today, Kate. And thank you to everybody who came. I know we have several here from the Coast Market Center, and it's really nice to have you here. So, all right, everybody, have a great day.
Thank you, Jodi.
Thank you, Jodi.
You're welcome.
Cool.
Bye.